Good evening again, everyone. So I think we are ready to start. And we will have now, we will have now Middlesex University team I versus Bolton University. I just kindly ask the members of the team to switch on their videos so they can introduce themselves and they can explain me how they prefer to manage their submission, their oral submission. Who will be the senior counsel, the junior counsel?
Hi, good evening. My name is Jennifer Hale. I'm just a second. Yeah. So I'll be using the other laptop for the video. My camera is not working. Is that fine?
It's not possible to change the device because one of the evaluation that we judge does is also the high contact, the way in which the oralist can interact with the judge also. So if it's possible to switch on another device, would be
Can
better.
you just give me 2 minutes then?
If you can. Yeah, of course, if you can, of course.
Yeah, sure. Just give me 2 minutes.
Thank you.
Right, I'm here. Thank you.
Okay.
Can I start
Thank
now?
you very much. Yes, I would like to know if you will represent just the senior counsel or also the junior, and how did you decide, your team decided to allocate the grounds that you have to face? Thank you.
Right. Thank you. So I'm the senior appellant and of the counsel for Mr. Leith Payne, and my junior is the junior appellant for Mr. Leith Payne, and I will be discussing the first round of appeal, and my junior will be discussing the second round of appeal.
Okay.
Okay. So I'll start. May it please the court.
Just 1 second, yes, just to recap to everyone the structure of this session. The session will last approximately 90 minutes. You will have 45 minutes each, which you can manage. So the senior counsel can talk for 40 minutes and the junior can talk for 5 minutes. It's totally up to you. There will be first senior counsel for the appellant, the senior counsel for the respondent. Then there will be brief possibilities for the appellant for a rebuttal. And then it will be the turn of the junior appellant, exactly in the same way. The only thing I ask you, please, if it's possible not to read too much. Of course, I know that most probably is the first time for you of attending a moot court. If you can avoid to read everything, and if you can talk with me, looking at me. And of course, you can use your notes. I totally understand that you can also read the legislation, the quote from doctrine, the quote from jurisprudence is, of course, totally allowed. Okay, please, let's start. Thank you very much.
Thank you. Thank you. May it please the court. My name is Zainab Raheel, and I'm the senior appellant of the counsel for Mr. Leith Payne. I will be assisted by my learned junior, Mariam Majid. For the benefit of your honor, the facts of the current case will now be presented. The appellant and respondent are both users of the Clevity platform, where users can create an account and trade in cryptocurrency. A minimum of 50,000 cash margin should be maintained in the user's account as a condition of trading in the platform. YAPL, a cryptocurrency, is automatically purchased by the respondent's alpha program at the best possible Clevity price. The price at which YAPL is offered on the platform is based on the average pricing for YAPL, as shown in the appellant's beta program. However, if no other users offer to sell YAPL, beta is programmed to automatically offer it at a greatly inflated price. During a routine upgrade, an error was made on June 10, 2022, causing Clevity to wrongfully exclude users who had less than 200,000 margins instead of the 50,000 margins that was intended. There was a glitch for 30 minutes. The only two users with margins above 200,000 at the time of the glitch were the respondent and the appellant. As a result, an automatic trade was concluded in which the appellant sold 100 YAPL for a price that was 250 times higher than the going market price, debiting the respondent's account by 250,000. The parties agree that the contested trade was concluded at a price that was 250 times higher than the going market rate. The respondent issued proceedings in the DIFC Court's Digital Economy Court seeking a declaration that the disputed trade was void for unilateral mistake. Your Honor, I will now address you on the first ground of appeal, namely that the DIFC does not have jurisdiction under Article 5A1B of Judicial Authority Law. My learned junior will be addressing the second ground of appeal, which states that the court stated that it is not necessary to examine the programmer's state of mind when designing the program under Article 37(1)A contract law. In common law, courts have general jurisdiction, which means they have the authority to hear any dispute over subjects to the extent that it has been given by the Constitution and legislation of the sovereign it represents. However, they hear conflicts except for those forbidden by state law. Some states, for instance, refuse subject matter jurisdiction for cases that do not involve state citizens and did not occur in the state, and those reserved for federal courts with exclusive jurisdiction. I refer Your Honor to the Mansfield Co. versus Swan 111 U.S. 379 1884 case. It was said that the power to declare the law is known as jurisdiction. Without it, no claim may proceed in the court. Would Your Honor prefer a summary of the case?
Sorry, I was muted.
Yes.
Yes, yes, if perfect, if you provide me a summary of the case. And also I would like, in the meantime, that the summary of the case was connected with the actual case, with our case. So why do you think it's relevant for our case? And I would like that you make a comparison between what you read in this judgment and between what is the actual case that we face. Thank you.
Right. Okay, thank you. So in a case filed in Ohio State Court, the claimants in two corporations with offices in Ohio and Michigan sought damages from the defendant railroad company and another entity for alleged violations of a contract for building a railroad. Claiming the partners were not Ohio citizens, the railroad corporation requested that the case be transferred from state court to federal court. The court determined that the Federal Circuit Court lacked jurisdiction over the case because the railroad company was not eligible for removal since the partner's citizenship was not expressly stated in the railroad company's pleadings. Similarly, Your Honor, both the parties, Ms. Rani and Mr. Payne, were not members of the DIFC and did not reside in the DIFC, hence the DIFC jurisdiction could not apply to them. Your Honor, I have two submissions to support this ground. If it pleases Your Honor, may I proceed with my first submission?
Yes, please go ahead. Thank you.
Thank you. Only one of the nodes is on a server based in the DIFC. The platform Clevity works on different nodes based on foreign servers worldwide to make online trading possible. One such node happens to be on a server based under the DIFC. Node is a component of cryptocurrency required for most popular currencies. The nodes are based physically in different parts of the world to conduct a transaction online and are based on other servers. It is difficult to determine whether the transaction could have happened on servers that were not located in the DIFC. Moreover, Your Honor, it is uncertain if the upgrade affected the other users that regularly participated in transactions and were based in the DIFC. The subsequent transaction might have happened on servers located elsewhere that were not part of the DIFC. Therefore, in terms of interpretation, it can be difficult for for Clarity clients to ascertain whether or not the server or node they choose through their server performs a transaction. Furthermore, Your Honor, transactions taking place from anywhere in the world from different servers can result in fraud. I would like to bring to your notice the D. Aloya versus Persons Unknown 2022 case, where the claimant claimed that the defendants had fraudulently misappropriated cryptocurrency. The first defendant's brokerage website hosted two digital wallets where the claimant had made multiple cryptocurrency deposits. The website appeared to be connected with a legitimate US regulated business, but it was not. The claimant was domiciled in the jurisdiction of England. The fraud was practiced upon him in this jurisdiction, hence, the court granted damages to the claimant. However, in our case, if both the parties that the servers only one of this node is based on under the server of the DIFC, so it can the other servers that resulted from the trade could result in fraud, and hence since both the parties did not reside in the DIFC, jurisdiction could not apply to them and they could not be sought to damages. If it pleases Your Honor, I would like to proceed to my second submission.
Sure, please.
Thank you. Your Honor, my second submission states that the jurisdiction did not apply. Alternatively, both the parties were not present in the DIFC when the transactions occurred. Clevity is a programmed software that utilizes its own algorithms and does not request the user's consent before choosing the appropriate servers for a transaction. The party's physical location was not in the DIFC. The transactions were conducted between the two parties on the DIFC-based server made available and accepted by the Clevity platform. This was done to make it evident that neither party had any influence over whether the server was based in the DIFC or not. In addition, both parties must reside in the jurisdiction for the rules and laws to be applied to the trade that is going to take place. In the case of Skate versus Solo Capital Partners 2022, the court erred when it determined that the Danish tax authorities' request to recover tax refunds that were allegedly prompted by the deceptive promises of firms based in England constituted an attempt to implement a foreign tax law directly or indirectly. As a result of both the parties residing outside the DIFC, trading outside the DIFC prevented the jurisdiction from being applied to them. In the appellant's view, I would like you, my honor, to overrule the decision made in the court of the first instance. Your honor, I will now be moving to my conclusion. In conclusion, no jurisdiction resulted in DIFC rules not applying to them. I would like to invite Your Honor to hold the decision in the Court of Appeal and overrule the decision made in the Court of First Instance. With that, Your Honor, this concludes my submission for the appellant.
Thank you very much. I have a question for you. I appreciate the fact that you think that you wrote in your submission that the DIFC is not a jurisdiction that applies to this case, to this contract. So I would like to ask you, which jurisdiction and why do you think it could apply in such situation, according with all the knowledge that you have that result from the study of this case? Thank you.
Right. So thank you. I think that since both the parties, Ms. Rani, she resides in Dubai, and Mr. Payne, he resides in the Sultanate of Oman, and both none of them reside in the DIFC. So I think when they knew that the contract was going to take place in the DIFC, they know that they are going to fall under the rules of UAE sometime. So I think the jurisdiction of UAE can apply to them.
Okay, thank you very much. So we can move.
Thank you.
We can move to University of Bolton for the oral list of the University of Bolton. If someone can switch on. Thank you.
Thank you, Madam Lordship, and may it please the court. My name is Fatima. I, together with my co-counsel, Enazil Ms. Razrani, I'll be dealing with the lordship. Shall I proceed, Madam Lordship?
Sorry, the line for me is not good. I don't know if our technician can do something, because basically I even didn't understand properly your name.
I think she has to just check her internet connectivity.
Thank you. If you can do something, because really for me it's difficult because I
Yeah,
can't
I also
hear.
could not understand
Thank
anything.
you very
That's right.
much.
Yeah, so if you can just recheck your internet connectivity, please, and then reintroduce yourself, that'd be lovely. Thank you.
Dear Lord, am I audible now?
Now, yes. Now I can hear you.
Thank you, Madam Lordship, and may I please the court? My name is Fatima, and together with my co-counsel Inaz Al-Jahmi, appear for the respondent on the case of Salid Payne versus Ms. Razrani. I'll be dealing with the law question, whereas my co-counsel will be dealing with the jurisdictional question. Shall I proceed, Madam Lordship?
Sure, please go ahead. Thank you.
My lord, the facts of this case are straightforward. The evidence will show that on June 10, 2022, a software by the name Clavity underwent a routine upgrade, which resulted to an error causing the software to wrongfully exclude all the users from the market who had less than $50,000 margin as originally intended, and instead changed to a $200,000 margin. Ms. Rani and Mr. Lee Payne were the only users in the market with a margin in excess of $200,000. And so for the next 30 minutes before the glitch was noticed, they were the only users permitted to trade. In the absence of any market activity, Mr. Payne's beta program automatically offered YAPL, the cryptocurrency, at a highly inflated price of $100 per YAPL instead of $10, which conclude to a disputed trade. Prevailing the market price, which in result debited Ms. Razi's account with an amount of $250,000. This all happened while they were unaware of the transaction. Now, this court should find in favor for the respondent for two reasons. First, the disputed trade was void for a unilateral mistake, and second, the court has jurisdiction over the claim against the appellant. My lord, may I lord proceed with my issue?
Sure, please. Thank you.
Seeking declaration that the disputed trade was void for the unilateral mistake, and the court concludes the claim to void dispute trade as an error within the transaction if there was a knowledge of the circumstances. Now, I have three submissions before the court. First, when we look at the data protection law, law number is to establish procedures and regulate the management of personal data that both the controllers and the processors collect from data subjects. Although there is no data subject in our scenario, the legislation is nonetheless important because it aims to protect how personal data is handled. Especially according to the Article 14, subclause 2 of the Data Protection Law, it states that a controller or a processor must put in necessary technical and organizational measures to guarantee that processing is carried out in accordance with the law. This includes any risk the processing may cause. And in our situation, it is pretty much clear that Mr. Payne failed to take into consideration the risk of their program and how it inflated the price by a method that takes advantage of the other party involved. Now, the Article 38 of the Contract Law of TIFC, Law number 6 of 2004, this states that an error occurring in the expression or transmission of a declaration is considered to be a mistake of the person from whom the declaration emanated. Here we consider the declaration as the way Mr. Payne programmed Beta, which would automatically inflate the price when there are no other sellers whose declaration has emanated. Here we consider the declaration which would inflate the price automatically. Law number 7 of 2017 of TIFC states that this law is to ensure the validity of the transaction made by the parties.
Excuse me, we had a technical, no, I had a technical difficulty. If you can come back of a couple of sentences, because I totally lost your voice, sorry.
Am I audible now?
Now, yes, thank you.
May I proceed, Your Lord? Okay. The Article 38 of the Contract Law of TIFC, Law number 6 of 2004, this states that an error occurring in the expression or transmission of a declaration is considered to be a mistake of the person from whom the declaration emanated. Here we consider the declaration as the way Mr. Payne programmed Beta, which would automatically inflate the price when there are no other sellers for Apple in the market. Now, when we look at the electronic transaction law of TIFC, law number 7 of 2017, this law is to ensure the validity of transaction made by the parties. And this law details the usage, formations, and the legality of electronic contracts. Now, the Article 16 of this law lays down that the validity of electronic communication as forming a contract. It states that an electronic communication is used for the formation of contract, the contract shall not be denied validity nor enforceable solely on the ground that the electronic communication was used for the purpose. Now, the Article 19 of the same law mentions that the contracts formed through automated messaging system are not valid form of contract as well, so long as the automation was started through a human interaction or an interaction of a natural person. Here we consider this, we relate this law with our case because that here the automation of the transaction was not automated by a human interaction in our case. So in that way, we argue that this contract can be disputable under this legislation. Now, the Corruption Agreement Act under the Uniform Regulation of Digital Transaction, Article 9 and 16 of this Uniform Regulation of Digital Transaction states that it talks about the data corruption. And in our case, we can apply this due to the incident which has occurred, caused this issue to occur. The transaction has been done under circumstances that have corrupted the agreement. Now, why we state here the agreement was corrupted or the transactions were taken under corrupted agreement is because the transaction was not automated through a human interaction. In particular, this made a change in the minimum balance requirement. Now, when we talk about the case law of A versus Persons Unknown of 2019, which comes under the English jurisdiction, this case set out how to define the fungible and non-identifiable crypto assets constitute property that can be bought, sold, and held on trust. Now here, the commercial courts granted proprietary injunctions against those who have fraudulently extracted or misappropriated traceable proceeds of digital assets. In this case, we can relate that since Mr. Payne had misappropriated the goods through a mistake in his programming, it is set out that the fundamental guiding principle of trust is broken here in this case. In our case, again, the Wong versus Darby case of 2019, which comes under the TIFC code, and the case of Ray Lehman Brothers International case of 2010 talks about the express trust, which is the guiding principle of a commercial transaction. In the case of Ray Lehman Brothers International case of 2010, Judge Briggs commented that the parties where commercial agreements and arrangements should be interpreted purposefully to ascertain commercial objective. In this sense, the disputed nature of the transaction calls into a question whether the trust was valid in the first place despite a transaction being made. Ms. Razi was unsatisfied with the result, and such could constitute the commercial objective being unfulfilled here. Now, when we look at the first GFS Australia Private Limited versus Mel case of 2022, this is actually very much related to her case here, because here in this case, Crypto.com is a cryptocurrency trading platform, and in May 2021, accidentally Forest DFS Australia transferred Australian dollars 10.5 million to an Australian woman, Devamanohari Maniwal, and this was due to an error in the processing of a refund, which was originally just 100 Australian dollars. The problem was sourced to be a human error, with the account number of Maniwal being inputted into the payment amount field instead. This error was noted 7 months later, that following December month. At this time, though the money had already been used in several transaction purchases, etc., the presiding judge of Victoria Supreme Court, Judge Elliott, this money. The judge of the Victoria Supreme Court.
Yes, sorry, I lost at least 45 seconds. You were the judge of Victoria. Do you want to try? I don't know. I asked the technician also if he's listening to us. If maybe try to switch on the camera could help, or
my camera is on, my lord.
Yeah, no, I think we don't have. Excuse me, Mr. Technician. I think he's not with us, or he's not listening. Let's try to switch the camera, if you don't mind. Thank you, your camera. I try also to switch off mine. Sorry, not on, off. Let's see if it's better, because I totally lost at least 30 seconds minimum. I was at Victoria when you first say, or when you say for the first time Victoria judge. Let's see if the technician is coming. Yes.
Yes, your lord. Am I audible now? My camera?
Yes, try to turn it off. Let's see if it can work.
On. Is there any issue with that actually?
Okay, let's try now. Let's see.
May I proceed, your lord, if you have no other. Oh, okay.
Yes.
May I proceed?
Yes, please go ahead.
So in this case, Forest GFS Australia Private Limited versus Ms. Maniwal case, the presiding judge of the Victoria Supreme Court, Judge Elliott, had given a judgment against Ms. Maniwal after the operating company GFS Australia had acted against a mistake in payment. In particular, they focused on the property that Ms. Maniwal's sister Gangodri had acquired, and it was being bought with this money. Now, the judge of Victoria Supreme Court had ordered Ms. Maniwal to pay Australian dollars 1.35 million and held the property was acquired in trust for Forest. The property was later sold with interest and costs being paid to Forest, GFS Australia. Now we'll link this case to our case here. Both here we conclude that in this case, Victoria Supreme Court Judge Elliott passed an order against Ms. Maniwal stating that it was a human error. And here in our case also we state that this is a human error for Mr. Payne, that he structured his program beta in a way that it takes the advantage of the market situation and it inflates the price of the apple. So now I conclude my submissions by saying that this court shall seek a declaration that this trade was void for the unilateral mistake. Thank you.
Okay. I now would move to back to senior counsel for the appellant, and I would like to ask the senior counsel if he has something for her rebuttal regarding what the senior counsel respondent just say. Oh, I think that well, with mobile, I think this is a message for everyone, for you, from the technician. Okay, maybe later. Thank you. Okay. Okay.
So, Your Honor, I think that the ground that she
also, sorry, if I knew that there were technical issues, so if there is something that is not clear, that the other counsel said, please feel free to ask clarification to the other counsel. Thank you very much.
Thank you. Your Honor, I think that the ground that she addressed was the second ground and about the disputed trade, and that was not relevant to the jurisdiction. So this does not, I think, apply to the first ground of appeal.
Okay. Okay. Yes. Let me check. Yes, can we come back to the senior respondent, I think, for that just spoke from University of Bolton, and if you can answer regarding the jurisdiction issues and focus exactly on jurisdiction.
Your Lord, my counsel Inaz Al-Jahmi will be dealing with the jurisdictional question. May I pass it on to her?
Okay, yeah. Or we can do, yes, because honestly, usually jurisdiction came first, because it's a procedural issue. So usually jurisdiction came first, and then the merit of the contract, the inner part of the contract, come later. So what we can do now is going ahead, I think, finish with the other two grounds, and then we can come back and talk quickly about jurisdiction, again, ground of jurisdiction and the ground of the validity of the contract. And you can have your rebuttal later. I will do like this if everyone agree.
As per your wish, my lord.
Yes, Your Honor.
Okay, so we can go back and start. We can come back with the University of Middlesex, and we can start talking about the second ground of the appeal. Just let me know who will be the oralist for you, and I would like a brief introduction of herself or himself from the oralist. Thank you very much.
Your Honor, my name is Ms. Maria Majid, and I shall be addressing the second ground of appeal in the question. May I proceed?
Thank you very much. Just 1 second. Take the time. Please go ahead. Thank you.
Your Honor, as you have heard, my name is Ms. Maria Majid, and I shall be addressing the second ground of appeal on behalf of the appellant, Leith Payne, namely, that the appellant, being the reasonable trader, did not have knowledge of the circumstance. I have two submissions to make, which can be found in my skeleton argument on page 6 and 7. First, both parties committed to the transit.
I interrupt you. Do you mind to talk more slow?
Okay.
Very slowly. Thank you very much. Thank you.
I have two submissions to make, which can be found in my skeleton argument on page 6 and 7. First, both parties committed to the transit to the function of the algorithm. Second, the respondent should have been aware of the risk. If it pleases Your Honor, may I proceed with my first submission? First,
Sure,
both the parties committed to the transit to the function of the algorithm. In this case, the disputed trade is not an error and is valid under the smart contract. For your honest understanding, I would like to give a brief definition of what smart contracts are. Smart contracts are programs stored on a blockchain that run when predetermined conditions are met. They are used to automate the execution of an agreement so that all participants can be immediately certain of the outcome, without any intermediary involvement or time loss. They can also automate a workflow triggering the next action when conditions are met. If it pleases Your Honor, I would like to refer Your Honor to the case Chio King Keon and DigilandMall.com Pte. Limited reported in the first volume of the 2006 Law Reform Commission at page 37. For Your Honor's benefit, I would like to direct you to page 6, para 10 of the skeleton argument in the appellant's bundle. For further judgment on the case, I would like to guide Your Honor by clicking on the case in the index on page number 1. Would Your Honor prefer a brief summary of the following case?
Sorry?
Would Your Honor prefer a brief summary of the following case?
Yes, please. And if you can connect the brief of the case with our actual case, it would be much more appreciated. Thank you very much.
Thank you. The respondent was a company that sold information technology products across the internet. As part of its business, operated a website owned by Hewlett-Packard and its own website known as Digiland Mall website. On 8 January 2003, employees of an entity related to the respondent, Digiland International Limited, which from further this point, Your Honor, would be referred as DIL, were undergoing a training session at the respondent's premises. A DIL employee inadvertently loaded contents of the training template onto the Digiland Commerce website, which then automatically and instantaneously initiated the insertion of similar contents onto all three websites. As a result of the mistake, the price of the laser printer was advertised at the wrong price of $66. The actual price was $3,854. All 6 appellants were graduates conversant with the usage of the internet and its practices and endowed with more than adequate understanding of business and commercial practices. In the early hours of 13 January 2003, the 6 appellants placed order over the internet for 1,606 of the printers. Confirmation notices were automatically dispatched to the appellants through the email. When the respondent learned of the error, the advertisement was promptly removed from the websites, and the appellants and the other 788 buyers of the printers were informed that the price posting was an error and that the respondent would not be meeting the orders. The appellant that brought legal proceedings seeking enforcement of the contracts. It was submitted on behalf of the appellants that the contract was binding and one which the respondent was obliged to honor. The High Court dismissed the action, holding the contracts were void because the appellants had actual or alternatively constructive knowledge of the respondent's mistake. The appellant appealed to the Court of Appeal. The appeal was dismissed. Hence, this case dealing with the issues of the non-mistaken party having constructive knowledge of the mistake should be distinguished from our case. As the disputed party concluded in the present as a disputed party concluded upon the agreement of the smart contract in the present case when the both parties were asleep and unaware of the unusual change in market conditions on the Cloudity platform. The main issue in the digilandmall.com case was that the respondent knew of the mistake. It was a unilateral mistake. However, in our case, there is no unilateral mistake, as both the parties were in the same state of mind when the trade concluded, and both were informed about the trade being conducted when they woke up. Therefore, for a unilateral mistake to take place, one party needs to be informed of the mistake. But in our case, that was not the issue. Furthermore, Your Honor, I would like to draw your attention to a point on page 19, last line, starting from in the absence of actual knowledge, that is continuing to the page 20. This point highlighted that when there is no actual knowledge on the part of the non-mistaken party, a contract should not be declared void since both the parties were unaware of the mistake. Moreover, I would like to direct your honor to page 20 again, 15th line, starting from knowledge. This point shed light on the fact that actual knowledge shall be construed through express admission or infutable evidence. However, since both of these elements are not present in our case, it makes it certain that the felon never had knowledge of the error and had only got to know of it when the respondent knew of it. Therefore, this case needs to be distinguished from the present case as the appellant did not have actual knowledge of the error and trade been concluded on its basis, resulting in no unilateral mistake. If Your Honor has no further questions, I shall proceed to my second issue under the submission.
No, please go ahead with the second submission. Thank you.
The second issue under the submission can be found on page 6, para 11, Your Honor. The second issue is that both parties' program transited within its parameters and the condition under which the respondent program was programmed was not aware by the appellant. If it pleases Your Honor, I would like to refer you to the case Thornton and Shoe Lane Parking Limited reported in the second volume of the 1971 Queen's Bench at page 163. For Your Honor's benefit, I would like to direct you to page 6, para 12 of the skeleton argument in the appellant's bundle. For further judgment on the case, I would like to guide Your Honor by clicking on the case in the index on page number 1. For the benefit of Your Honor, a brief summary of the following case will now be presented. The facts of the Thornton case are as follows. The plaintiff drove his car into a new automatic car park. He had not been there before. The plaintiff took the ticket to enter into the garage where his car was parked by mechanical means. On the plaintiff's return to collect the car, there was an accident and he was severely injured. The plaintiff claimed damages from the defendant's garage. The defendant contended that the ticket incorporated a condition expecting them from liability. It was held at the end that since the plaintiff did not know of the exemption condition and the defendant had not done what reasonably sufficient to bring it to his notice, it did not exempt them from liability. Hence, this case needs to be applied to the present case in a way that the appellant did not know about the condition under which the respondent's program was programmed. Since each algorithm has its own characteristics, it is unfair to claim that the appellant would have been aware of the respondent's program. Additionally, there is no fact in the present case in relation to if the respondent tried to tell appellant about his program's condition, nor it is clear if both the parties had traded before on Clevity. Moreover, I would like to direct your honor to page 13, para 1, in which it is explicitly stated that conditions need to be brought to the notice of the other party, and in the present case, nothing of such matter was done. Furthermore, I would like to direct your honor to page 15, para 6, that continues to page 16, second line, that when the parties accept the contract, the conditions under it are not important. Therefore, in the present case, both the parties' program contained pre-programmed.
Sorry, I can't follow. It's pretty fast. Could you please tell me again the two references, the last two references to the pages, so I can follow through the PDF?
Yes, Your Honor. Additionally, there is no fact in the present case in relation to if the respondent tried to tell appellant about his program conditions, nor it is clear if both the parties had traded before on Clevity. Moreover, I would like to direct your honor to page 13, para 1, in which it is explicitly stated that conditions need to be brought.
One, correct?
Yes. In which it is explicitly stated that conditions need to be brought to the notice of the other party, and in the present case, nothing of such matter was done. Furthermore, I would like to direct your honor to page 15, para 6, Second line, that when the parties accept the contract, the conditions under it are not important. Therefore, in the present case, both the parties' program contained pre-programmed instructions and when to buy and sell, and these algorithms, once activated, trade autonomously in accordance with the programming. Hence, this means that both parties' program functioned under a set algorithm by them and concluded the trade under the smart contract. An acceptance was made when program was activated due to the malfunction that occurred on Clavity. Followingly, on page 16, para 10, that follows to the second line explicitly infers that if a condition is known to a reasonable person, then only they are bound by it. But in our case, there is no such issue as the condition under which the respondent's program functioned were unknown to the appellant. Nevertheless, the trade concluded through the smart contract when both the parties were not aware of the transition. Furthermore, under the conditions set by the parties in their programmed programs, it was too late for the appellant to have taken action to prevent the disputed trade, as the appellant was asleep. Therefore, a reasonable person would not void the concluded trade, as the transition had been done through an algorithm known to the respective parties. With this, I conclude my first submission. If it pleases your honor, I would now like to proceed to my second submission. The second submission in the appellant bundle can be found by clicking on the second ground of appeal in the index. The second submission is that in this case, the respondent should have been aware of the risk when accepting the algorithm trading through the smart contract. The respondent, as a reasonable person, should have been aware of the consequences when she programmed alpha, as algorithm trading is an inherent issue of trading. I would like to direct your honor to the ground of appeal 2 on the index, so if your honor could move down to page number 7, para 15. Article 37, Section 2B of the DIC contract law explicitly states that if the mistaken party, which is in our case the respondent, is aware of the potential risk due to the circumstances, the mistaken party cannot void the contract. Hence, since the algorithm trading comes with its own risk, it is imperative for all the traders to be aware of the risk, and a malfunction in the program is no exception to this risk. Therefore, the respondent should have programmed his program to cope with the risk he was well aware of, as he is common user of Clavity, or should be able to endure the damages that come with taking such type of risk. Nevertheless, the manner the respondent programmed her program proves that she accepted the potential risk the program could cause. Therefore, even if the respondent made a mistake when she programmed alpha, the appellant did not make a mistake in programming beta, causing the respondent not to void the contract in accordance with Article 37 2b. With this, Your Honor, my second submission is concluded. To conclude, there is no unilateral mistake, as the appellant was unaware of the malfunction. The respondent accepted to do the trading under the smart contract and to take the risk of trading through algorithm trading. And for these reasons, the judge erred in dismissing the appellant's claim. The judge should have held that the claimant succeeded before the concluded trade had been formed between the parties to the smart contract. Your Honor, you have heard from my learned senior the authorities favor the smart agreement as being valid, and that there is no misrepresentation made by the appellant. Accordingly, I would like to invite Your Honor to find in favor of the appellant by holding the appeal and overturning the decision of the trial judge. Unless Your Honor has any further questions, that concludes the case of the appellant.
No, thank you for your submissions. So, due to the fact that we have a kind of overlapping with the grounds, I will ask you now. What do you think about the submission of the counterpart? What are your observations? So we can do the rebuttal in terms of merit in this moment. So can face now ground 2 of the rebuttal. What do you think of the submission of
yes,
the other party?
yes,
Do you have some observation regarding their submissions?
Yes, Your Honor. My fellow respondent, the senior respondent, she made a point regarding the Corruption Act and stating that malfunction that happened was under that. But as I stated in one of my submissions, is that malfunction is one of the risks that all the users should be aware of when trading for in a Clavity in a platform that does algorithm tradings. And also one of the issues that she raised was about mistake. There is no mistake in this case, as both the parties were unaware of of the error that occurred. Both had the same state of mind during that time, and and the appellant had no constructive knowledge about that. And there is no relevant mistake under the article DIFC as upholding the article as the article 37 is being upheld, which says that if the other party is also aware of the risk, there's supposed to be no unilateral mistake. And as I have told in my submission that the that the respondent was aware of the risk when he was trading through the platform, as he is a common user, there cannot be any unilateral mistake.
Thank you very much. I would like to ask you if you have some jurisprudence, if you read some jurisprudence, if you have some references to what you say regarding the risk, the acceptance of the risk in the moment in which we decided to deal with the platform. If you have some references regarding this, we can also read together the references if you have.
Your Honor, at this time, I do not have any. If you would give me some time, I can get back to you.
Yes, please. Thank you. Thank you. We can come back later with the references.
Thank you.
Thank you. So we can now come back to junior respondent, which will actually respond in terms of jurisdictions.
Yes, my lord. Am I audible and clear?
Very bad. Very bad. I can hear you very bad. Sorry. Yes. I mean, the technician suggested before if you can try to connect with the mobile data. I know it's not the best. I can hear that you can hear me because I can hear my metallic voice. Yeah, I will type.
I can hear you, my lord, but I'll try with my headphones if you like, because the microphone is there. Am I audible now? Am I audible now, my lord?
Very bad. Very bad. There is the technician that is hearing us. If it's possible to do something, because for me it's very difficult to go ahead in this situation. Thank you. No. Sorry, can you try to connect with mobile data? Your phone?
Yeah.
Thank you very much. Thank you. Sorry. Okay, so let's try to go ahead in this way. If you can't join with the phone, let's try. Thank you.
Am I audible, my lord, or am I echoing?
If you want to try to switch off the camera, maybe, okay, I try to switch off as well. Maybe the situation can improve, I don't know. Let's make a try. Thank you. Please.
Is it now audible?
Yes, now it's audible. Thank you. Please go ahead. Thank you very much.
Thank you. My lord, as it's already been stated, my name is Inasa Jahmi, and I appear as a counsel for the respondents. My learned counsel has already dealt with the law ground, and I shall now be dealing with the jurisdiction. Now, if it pleases the court, shall I proceed with my submission?
Yes, please, go ahead. Thank you very much. Go ahead.
Thank you, my lord. My lord, as it is brought in this case, that it is a fundamental rule of judicial authority law under law number 12 of 2004, the jurisdiction of this case is clear, where in Article 5, subclause A, subclause 1b, states that any civil or commercial claims which arise from the contract, no matter its completance, will be performed within the DIFC according to the express or implied terms of the contract. Further to this, if I may direct the court's attention to Article 7, Clause 3, it states that the executive judge at Dubai courts has no jurisdiction to review the merits of a judgment, award, or order of the courts. And in this case, it's the IFC. This stipulates that in this case, if Mr. Payne would like to take the case outside of the DIFC, he is still unable to have the relevant Dubai courts to handle it. Now, the point is also solidified in the judgment made in Barclays Bank and His Excellency in 2021. My lords, this case provides that the court stance on the UAE Civil Procedure Law 1992, or the CPC, is undisputed. It has no application on the DIFC and the DIFC court proceedings, which are solely determined by the judicial authority law. Specifically, they pointed out how Article 5A, Clause 4 of the legislation is a unique provision in the UAE, which allows it to operate in one directional system to limit the DIFC jurisdiction, but not for other courts in the UAE. It does not prevent the court from ruling on its jurisdiction, but rather it sets the limit on it. Now, in relevancy to our case, it reinforces that the stance of the court on the UCPL or the UAE Civil Procedure Law, as it shows that Dubai courts have no jurisdiction over DIFC law. Now, my lords, I will also begin by mentioning that the UAE Virtual Assets Law sets up the regulation of virtual assets or tokens through the establishment of the VARA, or Virtual Assets Regulatory Authority. However, VARA and the subsequent UAE Virtual Assets Law exclude any types of activities done within the Dubai International Financial Center, or the DIFC, basically. Rather, the DIFC uses rules and regulations set out by the DFSA, which is the Dubai Financial Services Authority, regarding virtual assets. In particular, the amendments made in Part 3 of the DIFC Law Number 6 of 2021 make changes to the market laws of 2012 that the following amendment mentions concerning Article 10 of market laws, that the provisions in Part 2 of this law and the rules made for that part shall apply to a person who has or intends to have units admitted to trading on an authorized market institution, or security tokens that are units admitting to trading on an alternative trading system. And may I put it to the court that this entails that only investment tokens are regulated under the DFSA, and as such, crypto or virtual assets transactions are done within the firms that are unregulated by the DFSA. As such, the jurisdiction and laws applied to the case will be strictly that of regulations provided by the DFSA rather than the VAR or VARA. Now, to refer this, another case known as Lakhan and Lamia in 2021. In the Court of Appeal case, the question of jurisdiction was put into focus on the point of the Joint Judicial Committee's involvement and how it can change the factors related to the jurisdiction. Now, the facts of the case present themselves that if any party wished to have another court, in our case, it's the Dubai courts, judge or on their case, a petition must be made to the